Priyanka,
Ma'am,
I created the YouTube link, Priyanka. I kept in chat box.
ma'am, can you please once again post, ma'am? I just joined.
Okay.
Huh, ma'am.
ప్రియాంక
Yes, ma'am.
పంపించాను చూసుకోరా ఒకసారి.
Yes, ma'am. Okay, ma'am.
నేను హోస్ట్ చేసేసేలా.
చేసాను, ma'am.
ఓకే.
ఇవాళ ఆమె సరిపోతుంది కదా నువ్వు ఎట్లా నీకు రావాలి.
కదిలినిపిల్ల సార్.
Jansi ma'am.
అందరూ ఉపయోగించే విధంగా ఎటువంటి రంగు రుచి వాసన
Hello.
Hello.
Yeah, good morning, sir.
Good morning, madam. May I know who is speaking, madam?
I am Dr. Jansi, sir,
Yes,
IPR
ma'am.
coordinator.
Yeah. Very good morning, madam.
Can I see you, sir?
Yeah, definitely. Just hold on, madam.
Yeah.
Yes, madam.
Good morning, sir. Thank you for
Morning,
accepting our invitation, sir.
Thank you, madam. Thank you
We'll
very much for
start
the
the
opportunity.
session. We'll start the session within 5 minutes, sir. I'm just waiting
Yes,
for
ma'am.
the participants to join, sir.
Yes, madam.
We'll start it exactly at 11:05 like that, sir.
Just I'll screen share the first slide, madam.
Okay. Yeah.
Yeah. Is it visible, madam?
Yes, sir. Yes.
Yeah, yeah. I'll switch on the video after 5 minutes, madam. Okay.
Okay, sir. Yeah.
దాంట్లో బాగా ఇన్సూరెన్స్ ఉంది అన్ని ఉన్నాయి.
Priyanka, am I audible, ma? Am I audible?
Yes, ma'am.
Okay. Good morning, all. I welcome staff and students to the workshop on intellectual property rights and IP management for startup. I, Dr. Jhansi Lakshmi, IPR coordinator. Welcome today's guest speaker, Dr. Bhavya Subbarao, assistant professor, RBVRR College of Pharmacy, and also IPR coordinator for taking up today's workshop. I thank you, sir, once again for accepting our invitation. I take again the opportunity to introduce our today's guest speaker, Dr. Bhavya Subbarao. Dr. Bhavya Subbarao has completed his B Pharmacy and M Pharmacy from College of Pharmaceutical Sciences, Manipal. During the period 1991 to 1997, he completed his PG Diploma in Patent Laws from Nalsar University, Hyderabad. Later, he received his doctoral degree, PhD, in Pharmaceutical Sciences from Andhra University in the year 2014. During his 23 years of academic and industry career, he was involved in teaching basic research, process research, and patent analyst. He got the opportunity in working with Department of Commerce and Industry, Department of Pharmaceuticals under the Ministries, Government of India as patent analyst. As patent analyst at Pharm Excel Hyderabad, he was involved in patent awards for the pharmaceutical industry for 4 consecutive years at the national level. He published more than 10 books, of which 3 are academic and the remaining are industry oriented. He has published about 40 research papers and reviewed articles at the national and international levels. He received 2 Best Paper Awards and 5 copyrights. His academic books published by PharmaMed Press, Hyderabad are Practical Pharmaceutical Inorganic Chemistry, Intellectual Property Rights in Pharmaceutical Industry, both theory and practice, Pharmaceutical Research Methodology and Biostatics, Theory and Practice. With this brief introduction, I welcome you, sir, and please take over the session for today.
Thank you, madam. First of all, I have to take this opportunity in thanking Dr. J. Achyuta Devi, Principal, RBR Women's College, and then Dr. M. Sumakant, Principal, RBR Women's College of Pharmacy. In addition to that, the organizing committee, Dr. P. Jhansi Lakshmi, Convener, IPR Cell, and then N. Priyanka, Member, IPR Cell, for giving me this opportunity. Now I will go directly to my presentation, madam. Thank you for the introduction, madam. So is it audible and visible, madam?
Yes, sir. Yes, you can.
Yes, yes.
You can.
So my current topic is intellectual property rights and IP management for startup. Okay. So let me just hold on, please. So this is the disclaimer. All the information provided is to the personal interpretation of the presenter. And then if any IP protected information usage should seek prior permission from the rights holder, if any. Now let us see the contents of the presentation. So I have just compiled into 4 heads, which is called as fundamentals, IP management necessity, approaches, and then the conclusion. So I believe that always the fundamentals are necessary, and then I started with the fundamentals. So now let us see what is intellectual property rights. So creations of the brain are called intellect. And since these creations have commercial value, they are called as the property. And then as these creations are being done by an individual, they are the rights of the individual, and hence they are owned by the individual, and hence the term has been coined as intellectual property rights. Now let us see what is the role of intellectual property rights. So intellectual property rights, it is believed that it will increase the economic growth of the individual, and then it indirectly increases the economic growth of the country. Hence, okay, government always try to take the, okay, safeguard the citizens by protecting the intellectual property by giving exclusive rights. And then it is the duty of the rights holder to protect his intellectual property. Means what I meant to say is, if you have an intellectual property protection which has been granted by the government, so government won't monitor. It is you have to monitor yourself whether your product or the, okay, intellectual property is being copied and then misused by someone else. Now let us see in detail what are these intellectual property rights. So the classification of intellectual property rights. So before starting the classification, I have to give brief history of what is this intellectual property rights and then how it has come into prominence. So after the World War II, economy of the countries has shattered, and then the countries realized, and then finally they have to come up with some United Nations and all. At the same time, some organizations being established. At that time, to revive back the economy, so general agreement on tariff and trade has been established. So around 1947 and so. So during that time, so when it has been established, even India was a member of the general agreement of tariff and trade. So the advantage with this GATT agreement and countries becoming members is, so they will have mutual understanding among the countries, and then they will have an exchange of trade with reduction in tariffs. So that is the main reason India has become a member of the GATT agreement at that time, so that it can exchange agricultural products for crude oil and all, and some industrial technology and all. So in that way, the GATT has become into prominence. So as time passed, it has been found that it is not only trade, but also that intellectual property rights and services play a critical role in trade. And then to upgrade GATT, okay, it has been converted into World Trade Organization. So in 1995, India has signed WTO agreement when it has been formed. Means the WTO, when it has been formed, immediately India also has signed the agreement, and then it has become the member of the WTO. So when it has become the member of the WTO, it has to also comply with some of the agreements which are, okay, with the WTO. So TRIPS is one agreement. So TRIPS is nothing but trade related aspects of intellectual property rights. So when this has come into picture, from 1995 to 2005, it has been given a transition period for India. So in that time period, it is necessary that India has to fulfill all the TRIPS obligations, at least the minimum. So the stringency depends upon the country's needs, the local needs, in other words, what I meant to say. So just because of TRIPS, we have to make sure that all the legislations which were not there earlier have to be implemented. And then those legislations which were there already earlier, they have to be upgraded. In that way, we have to, the intellectual property rights have become so prominent. And then by 2005, we were able to comply with the TRIPS. Now let us see more in detail of the intellectual property rights, the classification and all. Intellectual property rights is being classified into industrial rights and copyrights. So those rights which are industrial applicable, they are called as industrial property rights. And those are rights which are artistic and literature type, they are called as copyrights. Now let us see more in detail about the industrial rights and then the copyrights. Now let us see industrial property rights more in detail and what are the components which are coming under the industrial property rights that we are going to see now. The first one is the patents. So patents are meant for protection of the inventions. So when you have an invention and then if it fulfills novelty, non-obviousness, industrial application, and then if you are disclosing, which is called as enabled, then the invention may be granted with a patent and then you will have 20 years exclusivity. The next one is trademarks. So trademarks are given to products, and these products will be given with a unique trademark, which is a alphabet or a letter, or a number or a combination of alphabet and then a number, and then you'll have some symbols, okay, some even signature. Okay, all these are the things which are being taken into consideration. The color, various aspects will come into trademarks. So in this way, you are trying to get an identity for your product by the means of trademark, so that okay, the particular product, when a consumer purchases, they will have an idea that it is produced by so and so manufacturer, and then it will give an indication to the consumer saying that, okay, the quality of that particular product which is being manufactured that particular by that particular manufacturer is of quality, and then they trust it, and then finally they purchase it. In that way, okay, trademarks are being granted for the products. So for a trademark, you should have uniqueness, it should be distinctive, does not confuse public. So if these are not met, you won't be granted with a trademark for your product and all. So a trademark is for 10 years, and then it will be, okay, regularly renewed. Means in other, what I mean to say is, a trademark will be there forever for a particular product until the company exists and then the product exists in the market. Okay, so it is forever like. So some of the companies have they are not available in the market now, but their trademarks are still in the market, well known. Okay, so all these are the things which you have to take into consideration with respect to trademarks. The next one is designs. So designs are granted for articles, means any consumer article you have to take into consideration, water bottle or any other. So under these circumstances, why a design protection is required? So the aesthetic presentation of a design, it is found to be having industrial value, and then it is having commercial value. Under those circumstances, even the article is existing earlier. So if you bring out a new design, and then if it is unique and then original in public domain and then distinctive, under those circumstances, you may get a protection for your design for 10 years, and then it may be extended for another 5 years. The next one is the integrated circuits. So electronic goods, earlier you know that they are very huge in size, especially the radio and television and all. So as time has passed, it has become compact. So this is found to be having commercial value and then is industrial application. Under those circumstances, if your design is original, not commercially exploited, and then if it is distinctive, under those circumstances, you may get a protection for your design for 10 years. Let me go for the next slide. So the next one is the trade secrets. It is also called as know-how, and then it is also called as data exclusivity. So in India, we don't have a legislation basically, and then a lot of pressure is there from the international governments and organizations for implementation of the data exclusivity and then the trade secrets in India. So this mainly speaks about the tangible and intangible assets. Okay, all the information related to manufacturing may not be disclosed out. So forever it will be. So under those circumstances, okay, there should be some protection. So under those circumstances, India is not willing, especially relating to data exclusivity, because okay, if data exclusivity provision is given, the products entering, drug products especially entering into the market will be further delayed, and then it will be expensive for the different sections of the society. The next aspect is the geographical indication. So geographical indication, as the word itself indicates, geography means a location geographically. Okay, so those products, especially which are cultivated, and then it is having unique characteristics just because of the climatic conditions, or a particular product which is being manufactured by a group of people in that particular geographical location, and then they are skilled in that area. Okay, the other areas they are not skilled. So under those circumstances, if it is having commercial value, they have to have a protection, and then they are getting the protection in terms of geographical indication. And then if your product is unique in characteristics due to climatic conditions, and then if you're a person skilled in the art, okay, if he's having that unique product being generated, so you can get a geographical indication. For example, Tirupati Laddu you come across with Pochampalli saris, like that you will Kondapalli toils and all. So all these have been geographically indicated. So a geographical indication also, it is forever, something like every 10 years you can renew it. First you have to get it registered, and then later you can renew it. The next one is protection of plant varieties. So there are some plants, especially by hybrid generation, and then some new species being developed and all. And then the farmers, if they try to develop a novel, distinctive, and then uniform, stable, capable of identifying such variety, okay, does not confuse. Under those circumstances, okay, your hybrid plant which has been developed, okay, you may get registered and then you will have protection for, okay, 15 to 18 years, especially some of the horticulture plants and then some of the industries, they are trying to develop new strains of rice and all, and then they are trying to get the protection of the plant variety of that particular hybrid for 15 to 18 years. So the next one is, additionally, I have to tell that relating to protection of plant varieties, the vines. Okay, so vines were being developed from grapes and all. So that particular strain of the grapes, they are having unique cultivation and then unique taste and all. So all these are the things that people are trying to develop, and then finally they are trying to get the protection so that it is not copied, and then they have the exclusivity for that particular 15 to 18 years to get back the revenue. Okay, so in respect to traditional knowledge, if you take into consideration, it is the ancestor knowledge. So especially, for example, you are staying in Hyderabad and then you feel that a particular knowledge which you have got from your parents or your grandparents, and then you feel that you only know and then other people does not know. Maybe you have done a survey and then you have found that it is not existing in, at least in your locality or in your area and all. So, but after you file a, say suppose it has happened that some of the patents have been granted with using formulations of herbal, and then they were granted with a patent, and then later they have identified that it has a traditional knowledge. So so one region may be knowing that it is a traditional knowledge, another region may not be knowing it is a traditional knowledge. So what has happened was, because of this patent revoking attitude has taken place, so immediately the government of India has come up with a digital library, traditional knowledge digital library, TKDL it is called as. So, and then if you just go to Google and then click TKDL, you will immediately find that, okay, a list of various plants which have been, okay, traditionally known in various localities of India have been, okay, in detail they have given the information. So when you are trying to patent a particular herbal formulation or so, okay, so first of all you have to ensure that these herbs are traditionally known for their use and all. Under those circumstances, can I get the patent or not? All these are the things which you have to take care. So first of all, if you know the fundamentals, then it will become the easy aspect. So now let us go for the copyrights. So copyrights, I already told, literature and artistic work. So author rights for if you author a book or a novel or so. So artist rights for paintings, and then engraving some sculptures, music rights for sound pattern, and then film rights, cinema and documentaries, broadcasting rights. So especially news people, they will be broadcasting all the things and all. So they'll also have some exclusive right. Performance rights. Say suppose you have performed in a playlet, and then finally you will also have the individual people who are performing in that playlet also have some rights called as performance rights, and then photography rights. So all these are the rights which are available, and then if you have a registered okay copyright for those, you'll have the exclusivity with respect to at least 60 years in most of the cases, and then especially for broadcasting rights and all 25 years or so. So if I take into consideration the other rights, if the author is alive and then if he has okay published a book, and then the exclusivity will be for lifetime of the author plus 60 years. So these are some of the international guidelines, and then we are fulfilling those. Okay, if you see the TRIPS guideline, it tells that at least 50 years. Okay, we are giving more than what TRIPS is saying. Okay, so in that way we have fulfilled some of the aspects, okay, with respect to TRIPS. So if you see here, so the various components of the intellectual property rights, and then especially Patents Act, and then the copyrights, and then the trademarks were existing earlier, but the remaining components, they were not existing earlier, and then they were established later. So copyrights was also existing earlier. Okay, let me go for the next slide. So these are the some of the intellectual property offices, okay, controlled by the government, and then this is mainly relating to patents, designs, and trademarks. And then Control General of Patent, Design, and Trademark is the higher authority who is taking care of the entire administration of the patent office and all. So if you see here, we have in Nagpur a educational institute relating to intellectual property management and all. They try to bring awareness, and then they try to make the people get qualified, and then finally they are trying to make people to also involve in this field. So with respect to patent office, if you have an invention, you can file in these 4 offices basically. And then among these 4 offices, we are only permitted to submit in Chennai office. So all the places, all the states have been categorized into 4. And then in that particular regional office, you have to submit it. In case of designs, you have to submit in Calcutta. And then in case of trademarks in Mumbai, Delhi, Calcutta, Chennai, and Ahmedabad. And then in case of geographical indication, you have to submit the application in Chennai. And then if it is an integrated circuit, you have to submit in Delhi. And then if it is a copyright, you have to submit in Delhi again. So all these intellectual property rights, they are not in one single office. They are being distributed in different departments and different ministries. So it is your homework, which you have to do, that which intellectual property right is coming under which ministry. Okay, all these are the things which you have to check. Now let us go more in detail about the patents. So with respect to patents, basically it is a document granted by the government to the inventor for his invention, granting him exclusive right to make, sell, use, and import upon disclosure of his invention to the public for 20 years. Means, it is a government document, granted. Means when you have submitted your invention, so they'll check whether it is fulfilling the patentability criteria. And then if it fulfills, they will grant with a patent for that invention by giving a certificate. And then when it has been given with a certificate, you will have the exclusive right to make, sell, use, and import. Okay. So for 20 years, you have the exclusive. So it is your own invention. In addition to that, you will have a certificate saying that this invention has been granted with a patent. So once it has been granted with a patent, you will have the exclusive right, you have the patent rights, and then you will also make sure that it is not being misused by other people by using your invention, which has been publicly displayed. So once it has been granted, it is being indicating that you are completely disclosing the invention. So it will be there in the public domain. Now let me go for the next slide. So this is a typical US patent document. It is well organized, and then it is well available in the US patent database. Okay, this is one aspect which you have to see, the various components and all. So you'll come across right from the patent number, and then the bibliography, means who is the patent holder, and then what is the company name, okay, and where it has been first published, where it has been first submitted, in other way, and then in what all the countries it has been submitted. All that also you can get to some extent. Okay, if this is individual country patent, so that is what you are seeing. So in a patent, you will come across with various components right from the abstract. Just like a research article, you will come across with abstract, and then at last you'll come across with the claims, which will give the boundary of the invention. Now let us see the patentable subject matter. So if you have an invention, how we are ensuring that it is a patentable subject matter? Means you feel that your invention is, you have an invention. So you are filing an application in the Indian Patent Office. So they will check for novelty, whether it is non-obvious or not, whether it is having industrial application or not, and then whether it is enabled or not. So in this way, they will try to understand. Whether it is fulfilling all the criteria or not. Novelty means whether it is having inventive step. Non-obvious means person skilled in the art should be in a position to judge whether it is novel or not. Means you are in the technology field, and then you have a lot of expertise, and then some other person have developed an invention, and then when you see that invention, if you feel that it is completely something new, and then it is not existing earlier, under those circumstances it may become non-obvious. Okay, so industrial application, if your invention is not useful, or if it is not having any industrial application, under those circumstances it won't be granted with a patent. So disclosure, so you have to completely reveal your invention, only then it will be taken into consideration as a patent granting. Otherwise it won't be granted. Okay, so when you submit an application, they check for all these 4 criteria, and then if it fulfills all the 4 criteria, only then it will be granted with a patent. Let me go for the next slide. So these are the inventions not patentable with respect to the Patents Act 1970 and then the later amendments. So if you know what are not inventions, then you will know what are inventions. So the Patents Act has clearly indicated what are not inventions, so that you can judge the things and then finally plan and then prepare the invention in such a way that it will fulfill the patentability criteria. So let me go in more in detail about this inventions not patentable so that it will be more clear. So if your invention is frivolous, means there is no seriousness in your invention. So just for fun you have done. And then if you are submitted, the examiner will see that there is no seriousness in the invention, and then it won't be granted with a patent. So if your invention is a natural law, under those circumstances, it won't be granted with a patent. If it is for commercial exploitation, only for commercial exploitation, under those circumstances also, they won't grant with a patent. So if it loses the morality, especially the basic moral principles, under those circumstances, it won't be granted with a patent. So if it harms the health of the human, animal, plant, or environment, okay, usually human, animal, plant health, if it is affected, and then if it also affects the environment, under those circumstances, okay, they won't grant with a patent. So if you identify a new element, and then if you say that it is your invention, it is not considered as an invention. Basically, it is a discovery. Under those circumstances, it won't be granted with a patent. So abstract theory. So you have dreamt with a theory. Okay, last night you have a good dream, and then finally you feel that it is completely new, and then you also feel that nobody has that idea, and then finally if you just document it and then finally submit the application, they won't grant with a patent. Okay, so if you have an abstract theory or something, like you implement it, okay, you do the laboratory experiment, and then finally if there is some fruitful results, under those circumstances, okay, you can submit the application for patent. So the next aspect is, this is very critical point relating to pharmaceuticals: mere discovery of a new form of known substance, new use, admixture, arrangement, rearrangement. Okay, so new form of the known substance, especially in chemical industry or in pharmaceuticals, you'll come across with a particular drug manufacturing, and then later you'll develop metabolites or isomers or esters, okay, prodrugs, and then some crystalline forms. Okay, all these are the new forms of the known substance. So they won't be granted with a patent. So in the same way, if you identify a new use for already existing one, new use for a already existing one, they won't grant it with a patent. So if you just combine two components, okay, and then finally say that if it is that as your invention, and then the two components are already well known, okay, and those circumstances also, they won't grant with a patent. Again, arrangement and rearrangement. Okay, for example, you take into consideration a particular device, and then it is, for example, a particular product, and then it is well organized, and then the device has come. So after it has come into the market, some other person has rearranged the components, and then he has developed a new device. Under those circumstances, okay, it is just an arrangement and rearrangement. Under those circumstances also, they won't grant with a patent. Okay, so except, okay, especially in pharmaceuticals, if your invention is found to be having significant clinical efficacy, under those circumstances, it may be granted with a patent. So this clause, okay, especially this point, it is bringing out the stringency in the Indian country. Means, in other, what I mean to say is, okay, Indian government is very particular with this statement. Okay, section 3DEF, okay, it speaks about. So in foreign countries, what is happening is, if you bring out a new, okay, improvement to the already patented one, it may be granted with a new patent for that. So in that way, what they are doing is, they are trying to evergreen the patent for longer term than 20 years. So India is trying to prevent that. So if you have a new, okay, addition to the already existing patent, it may be given patent on addition, not as a new addition. Means the patent on addition for the new improvement, okay, it will be having the lifetime, okay, leftover of the parent patent. In other, what I mean to say, out of 20 years, okay, of a patent which is already existing, and then if you have come up with a new, okay, improvement of your already existing patent invention, okay, under those circumstances, if you submit a patent on addition, okay, they will give as patent on addition, and then the exclusivity term for that new, okay, improvement will be the leftover period of the patent term of the parent patent. Okay, so I hope the point is very clear. Let me go to the next slide. So these are some of the other aspects which you have to keep in mind, which are not inventions. Method of agriculture or horticulture, okay, it is not patentable. Okay, means, in other, what I mean to say, it is coming under a different act of the intellectual property rights. Okay, so which are not under this purview, they say that they are not inventions under this Patents Act, so you cannot protect it under patents. Okay, so you have gone to a doctor, and then he has given a treatment with a prescription pattern and all. So you only have gone to another doctor for the same ailment, and then he has given another prescription pattern. Okay, both are completely different, and then it has cured the disease. And then under those circumstances, the two doctors have come up with two different approaches of treating the disease. So whether is it patentable? No, it is not patentable. Okay, because it is naturally cured. Okay, under those circumstances, okay, when there is a natural cure, under those circumstances, you cannot get a patent for those, okay, indications and all. Means especially medical procedures, surgicals, curative, prophylactics, treatment of humans or animals. Under those circumstances, you won't get a patent. So the next aspect is plants or animals whole in part other than microorganisms, including seeds, varieties of species. So you cannot patent plants and animals. Okay, they are living things. They are living things. Okay, so except microorganisms. So there is a case called as Diamond versus Chakravarti case. So Diamond versus Chakravarti was a case in US, and then it has revolutionized patenting microorganisms, even though they are living things. So what Chakravarti was an Indian scientist who has got settled in US, and then this scientist in his lab, he has developed a new strain of microorganism. Okay, and then that microorganism is having so much commercial value in terms of, okay, breaking the crude oil. So then he has approached the patent office for getting a patent. Okay, initially Diamond was Chakravarti, the case is, okay, so Diamond was the judge, and then Chakravarti is the inventor. So when the case has gone to the court, the Diamond, based upon the legislations at that time in US, okay, living things cannot be patented. So under those circumstances, there was an argument between the two people, and then finally the scientist has said that, okay, it is not there existing earlier, and then it is just because of human interference in the lab it has been generated. And then finally, okay, he has argued a lot, and then the court has given a grant for that particular patent for microorganism. From that time onwards, if you develop a new strain of the microorganism which is not existing naturally, okay, it may be granted with a patent. So the next one, biological processes, biotechnology products, okay, then plants, okay, cultivation, animals, okay, so cloning techniques and all, okay, they are not patentable in India. Maybe in other countries, maybe it may be taken into consideration with respect to their legislations and all. Okay, the next one is mathematical business methods and computer program. Okay, so if I give a problem and then the different people will solve that problem in different ways, and then it is very unique from person to person. So can I protect that as a patent? Means no, it is not possible. In the same way, business method. Okay, so when you go to the market, okay, you will sell your product in different ways, and then one person will communicate in a different way, and then they'll have a supply chain in a different way, and then they'll have the business. So different companies will have different methods of business. So whether it is patentable? No, it is not patentable. Okay, in the same way, computer program. If I give a programming okay, task, and then different people will develop the algorithms in different ways. So whether everything is unique under those circumstances, okay, whether it is patentable means it is not patentable. Okay, so computer program, okay, I think you have the knowledge, okay, you have come across with the softwares, and then finally it is being protected under copyrights and are not patents. Okay, so as I already told, some of the components, okay, of intellectual property, they won't come under patents, so they will be coming under other intellectual property right components. So in the act they clearly indicate they are if they are falling, okay, under this, they won't be granted with that particular patent, but they will be protected under different category like. Okay, so mere scheme or method of performing mental act. Okay, so if in the class, for example, or when you're playing a game, okay, so what will happen is your style of presentation, it varies from, okay, class to class, and then at the same time individual will have different way of presentation and all. So under those circumstances, I will try to protect my presentation, means as a patent means, okay, it is not possible. Okay, so you may go for some copyrights also if it is possible. That is what. So in the same way, literary, dramatic, musical, artistic work, integrated circuit, traditional knowledge, okay, all these are not, okay, patentable, but they are protected under different provisions of the intellectual property rights under different acts. Okay, so inventions relating to atomic energy. So under national security reasons, okay, inventions relating to atomic energy, you cannot patent them. So in certain circumstances, the Controller General, what he will do is he will direct the invention to the central government, and then he will regularly update the government. If the government gives a permission, then they can patent it. For example, on some of the school students, they have developed a drone. Okay, drones are commonly available now, but what they have done is school people, they have done this. Okay, they have developed in a large size, and then they want to develop the drone in such a way that it can carry the individual person also. So that requires some permission from the central government, and then later they have sent it for the permission, okay, for that particular invention to continue life. So this is one aspect which you have to keep in mind. Now let us see. So what are the different types of patents? So you will come across with product patent, where you are protecting the molecule itself. Okay, so the next one is a process patent, where you are trying to protect the method. The next one is product by process, means here you are protecting the product along with a process. And then the other one is process by product. So for example, you have paracetamol. Okay, so you are developing a method of manufacture of that particular paracetamol. So you have only one single method, which is unique, and then it is fulfilling the patentability criteria. You got the patent. So some other company, the same paracetamol, they will be developing a different process, and then they will be filing for a patent. Means, so for a particular product, you may come across with different processes. Okay, so in a product patent, okay, you are trying to claim that particular molecule, so nobody will touch that molecule. Okay, so this especially comes with innovators, and then finally they will be patenting the particular product along with a process, maybe one or two processes. And then Indian companies, okay, what they are usually doing is for that particular product patented one, okay, they develop different processes other than which has been protected by patents by the innovator. For okay, they develop different other processes, and then they are developing cheaper processes, and then it is making the innovator companies also depend upon the Indian companies, because they are bringing out cheaper drug products, okay, which are even cheaper than those inventions for those which they have the process, and then it is not economical also. Okay, the next one is platform patents. This is another strategy which industries are using. For example, you take into consideration the tablet dosage form. Okay, so the tablet technology everyone knows. Okay, so under those circumstances, you know the general technology, how to prepare a tablet and all. Okay, but okay, that tablet technology is completely unique, and then it is having fulfilling the patentability criteria, and then they try to protect that tablet technology, okay, in a different way of developing the tablet. Okay, but when they are developing the tablet, what they do is they do the experiments with 4 or 5 drug products available in the market, and then they will develop the experimental data and then submit the application. But what they do is, okay, when they are claiming, they say that it is not only for those experimental 4 drugs, but also for those, okay, active pharmaceutical ingredients available in the market. Okay, we are also claiming for those also, not only for those which we have done the experiments. Okay, in that way, they are trying to protect the technology not only for those 4 active pharmaceutical ingredients, but also for the other active pharmaceutical ingredients, so that their technology is well protected. So in this way, you'll have a lot of competition, and then industries, they are trying to develop the technologies, not giving a chance to other people to use the same technology for different other drugs. Let me go to the next slide. Now let us see infringement. Infringement, if you take into consideration, so say suppose a particular person is having an invention, and then it has been granted with a patent. Okay, so the government and then the patent holder are the first person and then the second person. Now say suppose a third party, another company, knowingly or unknowingly has developed a product, and that product, if it is falling directly into the claims of the patented invention, then it is an act of infringement. Means knowingly or unknowingly, he has entered into the territory of the patented invention. So to understand the territory of the patented invention, you have to read the claims. So in the claims, you will come across more in detail what are the limitations of his invention. Okay, for example, I am doing a bulk drug synthesis. Okay, and then I have used, say, suppose in my 4 steps of synthesis, I have finally recrystallized with the water, say, suppose. Okay, and then okay, I have, if I mention in the claim only that I have used only water and then I put only water, I will give a chance to other people to recrystallize in other solvents. So it may lead to another patent. So what I will do is, in my claims, okay, what I will do is, okay, recrystallization in all polar and non-polar solvents. So when I mention in that way, I'm covering all the solvents, so that, okay, my protection will be, okay, boundary will be increased, even though I have limited my experiments with the minimum number of solvents and all. Okay, now look into them. Okay, so whether you are infringing or not, if you want to know, you have to check into the claims of the document. So if you want to know whether you are infringing or not, you have to see what are the different types of infringement. Okay, first of all. So there are 3 different types of infringement. The first one is direct infringement. The second one is doctrine of equivalence. And then the third one is prosecution history estoppels. Okay. Now let us see direct infringement. So direct infringement, as I already told, if the third party has developed a product and then if it is falling under the claims of the already patented invention, it is a direct infringement. Okay, so if for example, okay, the A is the inventor with the patent and B is the person, other party, who has developed a product, and then he is selling the product in the market. Okay, so now A, what he will see, he will completely monitor the market, whether his product is being sold by other people or not. Okay, so finally he has found that the similar kind of product is available in the market. He will bring it to his he'll purchase it and then he will bring it to, okay, his okay, premises, and then he will check whether it is his patented invention or not. Okay, so if he feels that it is infringing his patent, then, okay, he will file a case saying that, okay, he is infringing. So when it has gone to the court, okay, the judge will see whether there is any direct infringement or not. Okay, if it is falling under direct infringement, then it is a, okay, the case will be solved there itself. Okay, sometimes you cannot judge whether there is any direct infringement or not. Okay, so there is no direct infringement. So then you have to go for doctrine of equivalence. So what is this doctrine of equivalence? So in this, you are trying to, okay, do a test called as triple identity test, and that triple identity test is nothing but same function, same use, and same result. So let me explain with, okay, bicycle and tricycle. So initially, one of the inventor has developed a bicycle. Okay, he has invented it, and then finally he has patented it. Okay, and then later, by saying this invention, okay, another person has come with, okay, tricycle. He has increased the number of, okay, wheels. Okay, and then he has released the product into the market. Okay, so now the patent holder who is having the bicycle patent, okay, he has filed a case, okay, in the court saying that this tricycle manufacturer is infringing my patent. So then at the court, they check whether there is any direct infringement. No, there is no direct infringement. Okay, next they will go for doctrine of equivalence. So in this doctrine of equivalence, they see whether the products are having same function, same use, and same result. Okay, so bicycle and tricycle, you know that they have the same function, and then they have the same use, and then the same result. Means you are, okay, using a mechanism in which, okay, you are moving from one place to another and then finally reaching the destination. So under those circumstances, if it is falling under doctrine of equivalence, okay, so the bicycle patent holder will get, okay, may be permitted, okay, with his invention, and then the tricycle holder will not be permitted with a new patent and all. Okay. The next aspect is prosecution history estoppel. So this is another important aspect relating to pharmaceuticals and then chemistry industry. So some of the inventors, they try to, okay, develop the products in different pH, and then just because of to get a patent, they may reduce the pH range and all. Okay, and then finally they get a patent. So now another party, okay, they will try to develop the same product but with a different pH. Okay, so now the patent holder will say that he is infringing. So under those circumstances, the court will check for the infringement, direct infringement, doctrine of equivalence. Both are not helping, and then they will go for the prosecution history estoppel. So when they go for the prosecution history estoppel, they'll check, okay, the patent holders, okay, history of getting the patent. Means during his grant of his patent, whether the examiner of patent has suggested any changes or the inventor has done any changes. So based upon that, if the patent holder is found guilty just to get the patent by modifying the pH range to his okay expectations, okay, and then leaving the others. So under those circumstances, what will happen is, okay, the other patent may be granted, may not be granted. So it depends upon case by case. Okay, sometimes there are chances that the other person who has invented, okay, he may be granted with a patent. Okay, so in certain circumstances, he may not be granted with a patent just because of the prosecution issue. If the patent holder who is already having the patent, if he has done some modification just to get the patent, under those circumstances, if he has been found that he is guilty, under those circumstances, okay, okay, there may be a chance that the new invention may be getting granted with a patent. Let me go to the next slide. So this is again related to pharmaceuticals, mainly related to pharmaceuticals, and then it is based upon US FDA legislations, okay, US legislations, and then US Food and Drug Administration. So this is helping the pharmaceutical industry, okay, especially to release the drug product at a cheaper price. Okay, so Hatch-Waxman Act is one act which is balancing the mechanism between the innovator, generic manufacturer, and the patient. Okay, so as you know that I'll speak more in detail about this okay, balancing mechanism in the next slide. Okay, so the next one is, okay, what is the balance mechanism? If you see here, I'll show the picture also. So in that I will be explaining. So the generic manufacturer, he will be filing for a, okay, generic product, okay, which is identical to innovator product. And then when he is submitting his application, okay, he has to also, okay, indicate that the particular product is already having a patent by the innovator. And then he has to cite, okay, what is the patent number? Okay, what is the status of the patent? Okay, so para 1, para 2, para 3, and para 4 are being cited by the generic manufacturer, indicating that his product which is being, okay, submitted, it is already having innovator's product patent or not. Okay, based upon that para 1, para 2, para 3, and 4, they will judge. So what is para 1? Okay, so no patent listed. Okay, next one, para 2, patent listed but expired. Okay, para 3, patent listed and approved after expiry. Means, so there is a patent, the Drug Regulatory Authority will approve the product after the patent has expired. Means innovator's patent has expired only, they will approve it. So in para 4, the generic manufacturer is trying to, okay, challenge the already available patent, and then he is trying to, okay, release the product as early as possible if the drug approval takes place. Okay, so in that way, the generic manufacturer is trying to enter the market, okay, by filing the, okay, status of the patents of the innovator, and then he may be, okay, granted with the approval sometimes early itself. If it is challenged, okay, so sometimes you have to wait until the patent has been expired. So in this way, okay, the innovator, generic manufacturer, and patients, okay, they are trying to bring a balance mechanism. What is this balance mechanism? So this is a time scale of drug discovery, patent, and regulatory process. And then this diagram, I have developed it, and then I have copyright protected it. And then, so now if you see this diagram, so right from etiology of the disease to the generic entry, you are seeing the timeline. So the top line is the drug development in years. And then the bottom line, if you see here, okay, you are seeing in terms of patent years, regulatory approvals, market exclusivity, and data exclusivity. Okay. So what exactly is this? What exactly is this? So drug discovery, if you see, first of all, you will identify the disease. For example, COVID-19, it has been identified first. And then they started studying the etiology of the disease. And then they have taken they have isolated the microorganism, and then they try to establish the molecular level mechanisms, okay, molecular pharmacology of that particular microorganism in terms of identifying the targets for that particular, okay, microorganism. In terms of, okay, they are trying to understand the biochemical reactions for the growth of the microorganism. And then you are trying to identify, as an inventor or as a scientist, you are trying to identify, okay, drug targets to those molecular mechanisms so that I can inhibit the growth of the microorganism. Okay, so in that way, I will try to identify the targets either from the plant sources or from synthetic sources or from okay, natural sources like minerals. and then sometimes I will use the digital libraries, okay, and then finally I will try to identify the molecules, okay, which are promising, and those promising molecules I will conduct the preclinical studies, okay, and then if those preclinical studies are promising, okay, those molecules I'll take as the lead molecule, and then I will try to establish further, okay, better activity with the minimum side effects. And then I will go for the investigation new drug application, where I'm switching from the preclinical studies to the clinical studies. And then finally, if it is promising in clinical studies, I will go for the new drug application. So this entire process is being done by the innovators. So the innovators are spending a lot of time in, okay, spending money, and then okay, a lot of infrastructure they are establishing, and then finally if the drug product is found to be, okay, promising, then it will be approved by the authority, and then it will be released as new drug application. So when this new drug application has been granted with a, okay, drug approval for release into the market, okay, the innovator not only have the patent, means when he is having a lead molecule, immediately he will file a patent for that particular molecule, okay, and then finally the patent exclusivity will start, okay, so if it has been granted, means from the date of filing of the invention, he will get the protection, okay, even though it has been granted or not, okay. If you feel that you have an invention, and then if you feel that there are chances that other people can also file it, so you should be as early as possible, first of all, file it. So it may be granted at a later state, okay, but you have the protection, okay, since you have filed it, okay. So in that way, you have to take the, okay, initiative, and then finally at a later stage, whether it has been granted with the patent or not, okay, the drug has been approved. So when it has been approved, it may be granted with a patent, okay, and then you'll also have market exclusivity. So what is this market exclusivity? Okay, since the innovator has spent a lot of time and money, he has to get back the revenue. So under those circumstances, okay, the innovator will be given some benefit in terms of, okay, market exclusivity, means in terms of, okay, 5 years, okay, only he can sell it, and then nobody else can sell that particular product. So that in that way, he's going to get back the revenue, and then he will put that revenue in another invention or discoveries or whatever it is, okay. So in that way, after 5 years, okay, what happens is the generic manufacturer will try to enter, okay. The generic manufacturer will try to purchase the product from the market, and then he will develop the same product, and then he will do the bioequivalent studies, okay, and then submit the application, okay. So when he's submitting the application, he will say that, okay, the safety and efficacy has been already proved by the, okay, NDA applicant. So you have given benefit as market exclusivity and patent exclusivity. Now you grant with a generic for me, okay, so that the prices will come down, okay. So in that way, he's trying to bring out competition. So the government also will encourage this generic manufacturers enter into the market as early as possible, so that the innovator monopoly will be minimized. So in that way, okay, the first applicant who has developed the product and then submitted the application, under those circumstances, if he has been approved by the product, okay, he will be the first generic manufacturer, and then he will be getting exclusivity of 180 days, okay. So the innovator has got 5 years market exclusivity. So after 5 years market exclusivity, if the generic manufacturer has been approved with the product, okay, so he will have 180 days, means the innovator and then the generic manufacturer only will be there in the market. So the benefit with the first generic applicant is this 180 days, okay, he will have exclusivity, and then this is a very, okay, large time to some extent, and then they will get a lot of revenue with that, okay. So when the first generic manufacturer has entered into the market with a 180-day exclusivity, other generic manufacturers may not be approved with the generics. So they have to wait another 180 days, okay, 5 years exclusivity plus 180 days, and then later the other generic manufacturers can enter into the market. So in this way, okay, the first generic applicant will have the best benefit, okay, and then, okay, they will try to get the revenues. So what the government is doing is, it is trying to give exclusivity to the innovator. It is trying to induce competition by approving generic manufacturers drug products. So in that way, it is trying to, okay, release the product into the market, okay, at a cheaper price. So it is beneficial to the patient. So initially, if it is only the innovator product, okay, it is very expensive. Under those circumstances, the poor section of the society may not be in a position to purchase it. So the government will try to release the product into the market as a generic, okay, as early as possible, and then it will be available in the market at a cheaper price, okay, by inducing competitions. So when the competition increases, automatically the prices will come down. So in that way, they are trying to bring out a balance mechanism. Okay. Now let me go to the next slide. Yeah. Now let us go for the IP management concept. Okay. So intellectual property management, where it will come into picture. So first of all, if you see, okay, there are in the market, you'll come across with the professionals, okay, in terms of science background, in terms of patent agents, you'll come across. So in most of the cases, patent agents are science background people. Okay. So there is a patent agent, okay, examination also. So if you have science background, and then if you clear this patent agent examination, you can prosecute at the patent office. Okay, that is the advantage. Okay, so prosecution can be done. So if you are not taking any patent agent examination and all, still, okay, so many scientists are having this background knowledge of the patent legislations and all, and that is helping, okay, to develop inventions that are patentable. Okay, in that way they are trying to tune. Okay, so IP management is helping in that way. So the first thing what you have to do is, when you go for the IP management, you have to develop preliminary reports. What are these preliminary reports? Okay, you have to see the primary, secondary, and tertiary literature, and then finally you have to sort out all the things relating to that particular, okay, aspect of invention what you are planning. Okay, whether there is any, okay, patent or not. Okay, and then you are trying to, okay, develop a project in such a way that you are trying to ensure that, okay, if there are patents, what is the possibility that I can develop a new invention in such a way that, okay, it won't be infringing already existing patents. Okay, so in that way, I'm trying to develop, okay, a project. Okay, before the project is implemented by the company, okay, they will try to establish the reports, okay, based upon the literature search of the patented literature, and then okay, published literature and all, and then based upon the technology what they are planning. Okay, so they check whether there are any already patents expired. In that way, they will try to establish the things, and then if technologies are already patented and then still active under those circumstances, what can I do, okay, to get a invention in such a way that, okay, that is patentable and then it is not infringed. So all these are the things which I have to, okay. So what I'm doing is I'm trying to retrieve the past research and then establish non-infringing approach. Okay, so the next aspect what I have to do is, whether you are a patent agent or not, okay, as a technical person or a science person or a, okay, another, okay, science, other discipline people who may be working in the industry, okay, they have to monitor the things, okay, they are going in the right approach or not. Okay, if it is science background people, they will be more towards, they will be more towards, they will be more towards the technology side. Whereas the administrative side and all, you may have to be involved. Okay, under those circumstances, that's the technical people may not be much concentrating on that. You may have to communicate with other people and all. Sometimes you have to, okay, communicate with all the people. So you have to bring out a platform and all. So there are technical and non-technical people relating to, okay, science, which are who are completely, okay, involved in these activities of IP management and all. So it is necessary that you have to tune the researchers to the IP protection. Okay, so it is always possible that when you are doing an invention, okay, you will be diverting from, okay, protecting it from patentability. Okay, so first of all, you know what is patentability, then your approach will be in such a direction that it will be leading to patentability. So all that you have to take. So a lot of diversions will take place. So you have to bring them into the track. So you have to make sure that IP protection. So some of the patent agents, they are regularly doing that only. Okay, so when they are doing the technology in the industry, okay, these agents will be communicating with the scientists, and then they will be telling some of the indications. So if you do this sort of modification, that may lead to patentability criteria and all. So as I already told, biotechnological processes, okay, natural processes which are occurring naturally, okay, they cannot be patented in most of the cases, but there are patents which are involved with biotechnology also. Okay, so what techniques they are using, and then they are fulfilling the patentability criteria, and then they are getting the patents, is a, okay, technical issue. Okay, next one what you have to see is the technology transfer. Okay, in terms of IP management, you have to transfer the technology from company to company or within the company. Okay, so within the company, if you take into consideration, R&D people will be developing the product in a small scale, and then it will be projected to a larger scale in pilot plant and still to a larger scale in main plant. So they have to transfer the technology from step by step within the organization itself. So under those circumstances, you have to document everything, and then finally you have to give all the details so that it will be transferred appropriately, so that the communication is minimized, and then finally, okay, the technology will be established as early as possible. So in certain circumstances, okay, contract research organizations, CROs, okay, so these contract research organizations will be funded by the sponsors, and then they will be developing the entire product, and then after developing the entire product, they have to transfer the technology to the sponsors. So under those circumstances also, you have to document. So IP management is helping in that way. So in certain circumstances, two companies, okay, one company is okay, the innovator company, and then they have asked for developing the product at a cheaper price, and then they have developed at a cheaper price, which is not infringing. And in those circumstances, they have to, okay, check the IP, okay, aspects, intellectual property aspects, and then finally they have to establish the royalties and all. So in that way, okay, IP is helping. Let me go to the next slide. So this is one big issue, okay, where IP management is helping a lot. Okay, for example, you have a product, and then it is being patented by you in India, and then you, okay, export it to another country. Okay, earlier it is especially intellectual property rights are territorial. Okay, means another, what I mean to say is countries are trying to protect the inventions of the citizens, okay, for the country benefits, not to other country benefits. Okay, so if that is the case, okay, if that is the case, okay, your invention earlier may be granted with a patent, okay, but your invention is not protected in other countries. The same idea might have been protected by another inventor in another country. Okay, so under those circumstances, when you are exporting your product, okay, to another country, okay, via the country where the patent is there for that particular another inventor, okay, so that inventor, they may file a case saying that, okay, the inventor in India is trying to infringe my patent, okay, since his product enter into my territory. So under those circumstances, you have to bring out a communication between the patent holders and then the authority, saying that, okay, Indian patent, okay, is different from, okay, that country where it is halted, okay, saying that it is the invention is, okay, not infringing, and then finally it will not be destroyed or it won't be sent back, and then finally it will reach the destination. So in this way, so when you're exporting the products, there are issues that, okay, some of the countries, okay, just before 1995 to 2005, even India is not having all the legislations. In that time, okay, there are some international issues. Okay, some of the Indian products, they were, okay, they are being exported to other countries, and then they are going via another country. So in that via another country, okay, the authority or, okay, stopping the product not to, okay, go further to the destination country. Okay, the patent holders in that via country, they are trying to stop it, and then they are sending it back to India. So Indian companies are losing a lot. So there should be a communication between the countries and then the authorities and then the patent holders that, okay, this invention is not infringing, and then finally, okay, it can reach the destination like that. So in this way also, India has updated the communication, okay, by developing a website in such a way that, okay, so those inventors who is having patents, they can provide the information to the authority, okay, in that website, and then, okay, they can also indicate that this product is going via this country, and then, okay, don't stop it, it is not infringing, like, and then they'll also bring out a communication with the, okay, patent holder in that via country. Is that clear? So I hope that it is very clear. So the next aspect is, okay, especially the IP management, you have to coordinate and communicate with the researchers, patent agents, and then the patent attorneys. Okay, so a lot of communication gap will be there, especially patent agents, they are science holders, patent attorneys, okay, they are science background people, and some lawyers will be coming into picture. Okay, they are not having science background. So the researchers, the scientists, okay, they will be helping a lot. Okay, and then sometimes, okay, you have to, not only the scientists, you have to also, non-science people also, they have to bring out a platform of better communications and all. So in that way, okay, in industry, there are so many technical and commerce people or some other discipline people who are trying to establish the things with a good communication aspect and all. And then they are trying to, okay, minimize the hurdles and then trying to, okay, go further with the products development and all. Okay, so with respect to the IP protection, okay, again, IP management will come into picture. Okay, you have to do the filings at the national level and then at the international level. Earlier, I was telling that only for the country needs. Okay, but later, after WTO has come into picture, okay, even World Intellectual Property Organization also has come into picture. And then so many treaties have been signed by different countries. And then in that, Paris Convention is one, Patent Cooperation Treaty is another one. So in that way, what has happened is, so many countries have become members of these treaties and conventions. And then a US inventor, okay, can also patent in India. So in other, what I mean to say, an Indian inventor can also patent in US, okay, because they are the members of the conventions and treaties. So now what you are doing is you are only not protecting your invention in your own country, but also in other countries. Okay, so in the same way, foreign citizens are also trying to protect their invention not only in their country, but they are also protecting in India also. So these are mutual understandings, conventions and treaties. They are trying to bring out mutual understanding between the countries, and then you are trying to protect your invention not only in your territory but also in other territories. So there is a history for this also. So let me go to the history back here. So what exactly is the thing is, initially Germany was the one which has been recognized as the, okay, industrialized nation. And then okay, when it has been recognized, the prestige will be increasing, the, okay, economy of that particular country will be increasing. Okay, so what they have done is they have exhibited their products in an exhibition. Okay, later when another exhibition has taken place, and then US refused to protect, US refused to, okay, participate in that exhibition. So when in an exhibition, you'll be displaying your invention. Okay, you are disclosing your invention. Okay, there is no sort of protection in another country. So India, US inventors, they are not having protection in that country where the exhibition is taking place. So they did not participate. So this issue has led to the formation of conventions. The first convention relating to intellectual property rights is related to Paris Convention. So Paris Convention is one which has brought priority date and then national treatment. Okay, so national treatment means, okay, if India and US are members of the Paris Convention, for example, okay, you have filed an application in US, okay, for your invention for getting a patent. Okay, so you will be treated as national in US because India and US are members of the Paris Convention. So first of all, US has to give permission to the, okay, invention of that country's citizen, if there is any. Okay, okay. Say suppose in US, one inventor has filed the same invention, and then Indian inventor also has filed the same invention in US. Okay, so there are two inventions whom have to be given priority. So basically, if this convention is not there, okay, even if you have filed first in US, okay, what happens is the US citizen will get the priority and then he will be granted with the patent. Since you have become a member of the Paris Convention, you will be treated as national of US, and then finally you will get the priority even though US person has, okay, filed it. Okay, but okay, there are some, okay, even though US person has filed it first, okay, just because of priority, okay, what happens is in India you have filed it first, and then US person has filed later, and then you have filed later in US. Okay, and then just because of Paris Convention, okay, since they'll check when in the Paris Convention country who has filed first. Okay, in that way, okay, he will get the priority. Means in other, what I mean to say is, okay, in India he has filed first. Okay, in US he has filed later. Okay, okay, means the US inventor has filed later. Okay, and then Indian inventor has filed the application later to okay, US citizen, just because of Paris Convention, okay, in India he has filed first, okay, but filed in US later, but because of priority, okay, Indian will get the priority. So this will be a bit confusing, tricky, okay, to understand. So if there is any clarification in the question and answer session, I will just re-clarify it if anything. So this, the another aspect is dumping issues. Okay, for example, in India, you are manufacturing a product and then you have manufactured in large quantity, and then you want to dispose of the product, and then you have exposed it, you have exported to another country. And then in that country, you are selling it at a cheaper price than India. For example, in India, you are selling at 10 rupees. And then you have exported it, and then you are selling it at 9 rupees at another country. Okay, that country people will file a case saying that, okay, is dumping, okay, just to get the business. So that country people, so WTO will monitor in terms of anti-dumping, means, so it will try to check the countries, okay, how much measures they are taking in terms of anti-dumping. In other, what I mean to say, very recently one issue has taken place from France, okay, asbestos has come to India, okay, for okay, dumping, okay. So asbestos is carcinogenic, and then finally it will lead a lot of environmental problems and all, okay. So even though there is an understanding between France and then India, later the issue has become a big issue, and then later the ship has gone back to France. Okay, so dumping issues will come into picture. So all this, how much, to what extent anti-dumping measures they are taking, every country is taking, that WTO will monitor. Okay, so in that way, okay, the issues will go to the WTO among the countries, and then it will also be resolved. Okay, let me go to the next slide. So now let us see the approaches. Okay, so what exactly you have to do? You have to refer to individual country and specific country databases. Okay, and then understand the differences in legislations, and then you have to collect data and analyze. And then you have to also see a particular product, what is the market potential, and then whether that product is having any exclusivities. Okay, means data exclusivity, market exclusivity, patent exclusivity and all. So you have to also establish product life cycle, okay, and then the volume of business, and then the price wise also you have to establish. And then in that way, you'll try to also ensure that whether there are any, okay, off patented products. Means, in other, what I mean to say is, there are chances that you can develop a product. There are chances that you can develop a product in such a way that if it has been granted with a patent, and then finally I can make sure that, okay, if it has been off patented, then I can take that product and then develop the product and then release into the market. Means its patent has expired. So if you refer to the databases, various country, okay, patent databases, they will also mention, okay, what are the patents expired. Based upon that, can I develop the same product and then release into the market? That in that way, I will try to get the, okay, establishment. So in this way, IP management is helping in different ways. Okay, let me go to the next slide. So these are some of the search engines, okay, and then this is Indian Patent Office, okay, search engine, and then this is WIPO, European Patent Office, Regional Patent Office, then the WIPO, and then later the US Patent Office. Okay, so if you click this, you'll go to the directly the patent search database and all, where you can search it. The last one is relating to, okay, a marketing strategy which is being used by the innovators, and then everyone has to refer to this. Okay, how evergreening of patents are being done by innovators in foreign countries, so that their product will be lasting for longer time in the market, and then what tricks they are using. And then I already told patent on edition, okay, is the one which is helping India in stringency, and then we are trying to prevent the evergreening of patents. Okay, so the same is being used in foreign countries, and then they are getting more than 20 years of benefit. Okay, and then they are releasing the product into the market. Okay, and then it will be there for a longer time. So everyone has to refer to this okay, website. Okay, especially this is a video. It has been given very clearly the, okay, the strategies, the failure issues, and then the, okay, the benefit issues they got, okay, by different companies and all the case studies you'll come across with. Let me go to the next slide. So at this stage, you should know what is invention and innovation. If an invention is leading to another invention, okay, that invention may success into the market, or it may stop. Okay, just if the animals have died just because of toxicity and all. Okay, if there is no market at all, under those circumstances, that invention may lead to another invention, or it will be stopping. So in case of innovation, invention will lead to release of the product into the market. Okay, so the invention may be the final stage. So that invention may lead to release of the product into the market. For example, COVID-19, you take into consideration, some diagnostic kits have come into picture. Okay, so some of the scientists, they have developed the technology. Okay, and that invention is well prominent, but they have to develop into the market model, so that you have the kits, testing kits and all. Okay, just if you put one drop of your sample of saliva or so, it will give the indication whether you have the COVID-19 disease or not. So that market model, that may not be taken into consideration as a further inventions. Like, if you have the final invention, developing from the final invention, the prototypes, the market models, it may not be considered as an invention, but still it may be an invention for scientific point of time. But you're successful in releasing the product into the market. So sometimes a product may be innovative and then it has been released into the market, but it is not successful, but still you are successful. At least you have released the product into the market. Whether the consumers have received it or not, it's a different issue, but it has entered into the market. So that is the difference between invention and innovation. So you have to aim in such a way that your inventions will lead directly to the innovations. And then in most of the cases, especially when you're doing the basic research, your invention will lead to another further inventions. You'll try to identify new problems and then try to solve those problems, and then it leads to new inventions, but not innovations. So you should have the objective, depending upon, you should have some commercial bent of mind also, when you're doing research. So I have to release innovative products so that, I can survive in the market. So companies directly, they won't start with the inventions, they start with innovations, so that their product is available in the market, they will get the, revenue. And then later they start with the basic research of inventions, and then they spend on further inventions and all until they reach the innovations. So in that way, the innovators have established the things. And then some of the innovators, if you see, they are more than 100 years old. So initially they have struggled a lot, and then they have spent a lot of money, and then finally they have established the innovations. So if you see all the products which are getting into the market, most of the things are, if you see the TV channels and all, most of the innovations you are coming across. Those innovations, if you see, they are well established, right? They have done right from scratches, and then finally they have established. In the same way, in India also people are doing, but some products, even though they are innovative, they can be received by the inventors or the public, but the sale is not that much. So that is lack of awareness or safety issues. They are not taking much and all. So there are innovations in India also, but the sale may not be that much. So that has to be encouraged. So these are the aspects, again, approaches. If you have an idea, check whether your idea has been already worked or not, and then check for the exclusivities, and then try to develop the volume of the business. And then what is the price? You have to establish who are the number of competitors. Whether new designs have to be established for the same product. And then try to establish the product life cycle, and then release the product into the market. So in this way, you're trying to see. And the point, the last point I want to emphasize, drug master files. So drug master files, especially relating to pharmaceuticals, they are being submitted to the US Drug Regulatory Authority. And then at the same time, Indian companies who are supplying the product for Indian market also, they are submitting the drug master files. So when you refer to the drug master file database, you'll try to know how many companies are manufacturing that particular chemical, or that active pharmaceutical ingredient. So in that way, you'll know how many competitors are there. And then finally, whether I can have the volume of business, whether there is any shortage, if I manufacture this at a cheaper price, can I withstand? All these are the things I can establish. So this is a product life cycle. So if you see the y-axis, you will see the sales, and then the x-axis with the time. Okay, if you are an innovator, you will be struggling, okay, to establish the of the product, and then initially it won't be available in the market, and then it won't be any sale will be there. So you will be it will be in the product development stage. So you'll be spending money. So that red line will be showing the negative side. Okay, so when you introduce the product, okay, it won't reach to the public in large quantity. So again, okay, because people are not aware, but there is some sales. Okay, but still you are on the negative side because you did not get back all the revenue. So as time proceeds, in other what I mean to say, the growth phase will be there. So then you'll get the the revenue. If you go further, the maturity means the maximum consumption has taken place, and then finally a stage will come, a decline phase. So there are products in market which have showed maximum business and later completely declined. I mean there is no further business at all. Okay, so for example, relating to coronavirus only, there was so many issues historically, and then people have developed the product and then they released into the market, but the disease is not existing. So this is the situation. So they have released the product into the market by struggling a lot, but the disease is not there further. So all these are the issues which will take into the risk factor. So in that way, you have to make sure that so what is the possibility of business? Okay, and then in that way, I have to develop the life cycle and all. So this is one aspect. One second. The data, I have to do the data analysis, and then these are the drug master files which have been filed by various countries in US. Okay, and then in that way, from 1957 to 2020, so many companies have filed the drug master files. And then India is also playing a prominent role among the countries. India is playing the prominent role. Okay, so this is as a whole the entire global filings in US FDA. Why I am following US FDA is because it is the most established, well established regulatory authority. They have strong databases, and then their legislations also indicate that it has to be disclosed. Okay, transparency. Okay, e-governance. All these are the things which are coming into picture. This is from a paid database. Okay, product patent expiry. So this is from IMS. Okay, it's a very expensive database, and then this is being provided by Dialog Pro at that time when I was in ARMEXL. And then we are trying to project what are the future patents getting expired. Okay, means from 2011 to 2030, how many number of product patents are getting expired. So by this, I will know if I want to release a product in 2030, okay, when I have to start, whether I can start now and then make the product ready and then submit the application in the authority for approval or not. So sometimes too early, starting the project may lead to loss, and then too late also will lead to problems, because you won't have the business and all. So many competitors will be there. So which company is doing what, you don't know. So all these are the things which you have to keep in mind. So you have to be as early as possible. Okay, that particular aspect of doing the research and all. So this is one another database, which is called as Orange Book, which is, as I already told, US legislations is very legislations are stringent. All the information has to be displayed in the website as e-governance. So Orange Book is giving all the list of drug products approved in by the US FDA for the US market. So you will come across with the product ingredients, strength. Then you'll come across with the route of administration. What are the patents filed by the innovator? When they are getting expired, when the market exclusivity is expiring. And then are there any utility patents, use patents? In India, we don't have new use patents. Whereas in certain circumstances, some of the innovators, they might have patented for a particular disease condition. And then that may give a chance to Indians to develop the same product for a different disease condition. And then they are getting it approved in US. So in that way, you are trying to monitor the patents available in US Orange Book. You are studying that patents, and then you are trying to develop the products in such a way that they are not infringing. Either you are trying to challenge the patents and then release the product into the market as early as possible. Or tentatives. Tentatives means new route of administration, new combination, new strength. new indication, okay, which the innovator did not release the product for that particular, okay, combination strength or a new route of administration or indication. Indication means new disease condition. So let me go to the next slide. So this is again market exclusivity of various innovator products, okay, approved by the US FDA and then their data, okay. So when the product is getting expired for the market exclusivity. So as I already told, innovators market exclusivity is for 5 years. So after the 5th year has been completed, the generic manufactured product should be there in the market very next day. So if that is the case, how early I have to start? Okay. So when the market exclusivity, when the patent exclusivity will complete, all these are the things I have to take into consideration. So these are the drug products approved by, okay, the US FDA for, okay, new drugs and then the generic versions. And then these are the top 20 countries. And then among these top 20, one of the Indian companies also existing. Okay. So top 100 companies, they're competing a lot and then they are playing a critical role in releasing their product into the US market. Let me go to the next slide. So this is related to, again, Indian, okay, companies filing NDAs and ANDAs. So most of the companies are filing generic applications and then only a few companies are filing new drug applications. Okay. So Indian companies are not real innovators, but to some extent they are also innovators, but not the, okay, as such the main innovators. Okay. So they are trying to develop new route of administration, new combination, new strength. Okay. And then they are also trying to, okay, establish the same drug product which has been, okay, released by the innovator in the same way for a new use. So in that way, they are trying to develop new drug applications. And then they are also trying to establish the preclinical and clinical data. And then that is the main reason they are also called as NDAs. Okay. Even though they are not, okay, true innovators. Okay. They can be called as generic manufacturers, but they are filing the new drug applications to some extent. Okay. Let me go to the next slide. So this is various Indian companies who have released their first generics. Okay. And then they have, okay, they got the maximum benefit. Okay. Whether they got the benefit or not is a different issue, but they have tried at least, okay, in trying to release the drug product as first generic as early as possible, so that they get the, okay, market benefits. So the revenue will increase and then the company will grow. Okay. So this is another aspect. So this is orphan drugs. For example, what is an orphan disease? Okay. For in US, it has been defined that, okay, if a particular disease is occurring, okay, in 2 lakh people or less, it is called as orphan disease. For example, okay, for example, US population is huge, right? So out of those, okay, huge population, okay, if that disease is occurring up to 2 lakh people, okay, and not more than that, it is called as orphan disease. So under those circumstances, okay, some of the companies are trying to develop products for those orphan diseases. For example, you take into consideration, cancer is an orphan disease. Some of the types of cancers, they are orphan diseases. So you take malaria. Malaria is common in India, but it is an orphan disease in US. Okay. So how the country defines, okay, it comes into picture. Okay. So orphan disease, some of the companies, they are trying to develop the products as orphan drugs, and then they are trying to get the benefits in a different way, because they are not, okay, not having much business, because only 2 lakh people maximum or very less people will have that disease, and then the product consumption will be less, and then they have to spend a lot of money and then release the product, and then it won't be, so much of product will be waste. All these other things will take place. So under those circumstances, the government is giving, US government is giving special benefits, okay, in terms of, okay, filing the, and then approval procedure faster, at the same time giving exclusivity for longer time than regular. Okay, in terms of pediatric exclusivity, take into consideration pediatric disease conditions and all, the consumption will be less. So market exclusivity of 5 years plus another, okay, 180 days they will give as periodic exclusivity. So this way they are getting the benefit, so that they will have the business and then they won't be under loss. So US has come with a new, okay, aspect called as competitive generic therapy. where some of the first generics applicants, okay, they are giving special benefits, okay, based upon the patent status, whether they have to be given 180-day exclusivity or not will be decided. At the same time, okay, they will try to do the procedure of approval faster. Okay, so this has been initiated by the companies itself, so they have to trigger it, and then finally, if they want under this category, it will be approved at a faster pace. So clinical trials is one another way how you can monitor the things, and then finally you can identify some of the products which may be needed in the market. Maybe the innovators volume of business may not be sufficient. Under those circumstances, you can develop the same product and then release into the market. Okay, so this is different levels of the clinical trials. BA/BE studies, okay, gives an indication of generic manufacturers releasing the product into the market. So interventional and observational studies are some basic researches taking place. Okay, so post-marketing surveillance is one other aspect. The product is already available in the market, and then you are seeing for the adverse effects and all. So in this way, you'll try to know the status of the product, and then you can develop IP management in such a way that, okay, I can launch new products. So let me go to the next slide. So let me come to the conclusion. So what are the promising issues? Make in India is one aspect which is promising. And then startups, okay? Startups are not only wet laboratory, but are also dry laboratory research is taking place a lot in terms of clinical services, SaaS programming, data services, okay? And then I already told, report submissions, okay, whether to take up the project or not, okay? Some data analysis, okay? IT companies are doing all this. Post-marketing surveillance also being done by the some of the IT companies. Okay, big consultant companies are doing post-marketing surveillance analysis and all. So SCZs are coming in various sectors, not only relating to pharmaceuticals and chemicals, okay, textiles, clothing and all. Okay, they're coming up. Okay, so in that way, it is helpful in IP management. So patents are not only for pharmaceuticals and chemicals, but other sectors also. So I'm trying to emphasize on pharmaceuticals, okay, so that you will tune it to the other sectors. So and then use the same, okay, aspects wherever it is possible. Okay, even in engineering also. Okay, so IP increases industry's tangible and intangible assets. Okay, intellectual property rights, as I already told, trade secrets, patents and all, they are trying to help the industry to increase their share value, market value. And then finally, you are increasing the economy of the country individually as well as the, okay, company wise and then the country wise also. So with this, let me go to the next slide. So these are some of my books, okay, just to have added information. So I have just included so that even biostatistics services, okay, I'm telling you, okay, they're also having a lot of IP management and all, okay, that will be helping out. Okay, so this is another book which I have published. Okay, with this, I thank the organizers and the principal madams for giving me this opportunity. If there are any questions, okay, I will take up.
Thank you, sir. That was a very elaborative lecture on IP management and IP rights. So
Thank you,
I request the participants to pose the questions so that sir is ready to answer. If any questions are there, please put your questions in the chat box, or directly you can unmute and ask the question directly.
Madam, if there is any time, I will try to play this video, or else you can
Yes, sir.
okay,
Yeah,
check the
still
video and
20
tell you to
minutes
speak.
time is there.
Yes,
You can.
yes.
You
Yeah,
can.
I'll try to, okay,
Yeah.
so switch on it, whether it is possible or not. Let me check it. Is it visible, madam?
Yes, sir. Your
Yes.
slide is visible.
Yes, yes. It is from Google, from the internet only.
It's not playing, sir, the video.
It's not clear, madam.
Not it started.
Sorry, madam. 1 second, madam.
Yeah.
Is it visible, madam?
No, search engines, that link, that slide with the links is visible now. But the video is not playing. So when you click
Okay.
that, it should play, no? So the video is
Yes,
not
yeah.
opening. Yes.
Oh, just 1 second, madam. Just 1 second. I'll replay it.
Yeah.
I will reshare it. Is it audible, madam, now?
Yes, sir. Volume, its audio is not coming.
Just 1 second, madam.
Video is coming, but audio, we are not able to hear the volume.
I did the maximum, madam. Okay,
think-
anyhow. That is technical issue. That is a technical issue, madam.
Okay.
So I'll stop it. Okay. If there are any questions, I will take it, madam. Or else, okay, people can watch it from the Google search and all. Okay, farmer marketer. Okay.
Okay. Sir.
Yes. In pharmaceuticals, this has become a part of curriculum, madam. So students are aware of. I'm not sure with the BSc people and all. Oh, in that way, I will try to explain the maximum possible in the
Okay.
limited time.
Okay.
So hope I hope that the students have got the basic fundamental concept and all.
Priyanka, can you help, sir, for how to play that audio? If possible.
Okay, if that is the case, I will try to re-initiate it, madam. Just let me check once. Is it audible, madam?
No, sir.
No.
Okay, anyhow, madam.
Sir, while sharing, if you just see if it is an option like sharing entire screen.
Just 1 second. Now you check, madam.
No, sir.
Yes. Hello. Hello.
కారం ఎక్కువ ఉంటుంది కానీ ఫ్లేవర్ లోపల ఉంటుంది.
It's not audible, sir. Sir, your audio is off, sir.
Madam, I will do one thing, madam. Let the students refer to that from the internet. If there are any questions, okay. Otherwise, I'll just clarify some of the issues if there are any from my side also.
Okay, sir, no problem, sir.
Yeah. So let me give some of the key points. Okay, especially in industry, they are doing a lot of to take up a project. What they are doing is at least they are spending 6 months to 1 year in collecting the data from various libraries. Okay, so if I want to develop a process for a particular product, they are trying to go to IICT, or they are using the patent databases. They are using the online databases which have been purchased, and then they are retrieving all the processes for a particular product, and then they are trying to develop the scheme for each and every process, compile all the schemes. Okay, then they are trying to identify, is there any possibility for a non-infringing process, okay, by checking whether the patent is active or not, and then they are developing the products. In certain circumstances, they are even developing the products in such a way that even though there is a patent, they are trying to develop in an economical manner, okay, than the yields, okay, in terms of yields and all. So it is becoming more commercially viable, and then they are trying to non-infringe. In certain circumstances, even though the patent is there, they are having a tie-up with the innovator who is already having the patent, and then finally, okay, they are developing their technology, selling the product to the innovator in a collaborative way, and then releasing the product into the market. So this is one strategy which is being used. So other aspect which I have to tell is the BOLAR provision. So already a patent is there in the market. Okay, so when there is a patent, can I do research? Okay, so as a institutional person, can I do research or not, whether it will be an act of infringement or not? So under research and development, under non-economical conditions or no business conditions, okay, even if it is patented, okay, you can do the research, okay, and then sometimes, okay, if you are doing any commercial business out of it, then the patent holder will file a case on you. So in most of the cases, innovator, they take into consideration as non-economical grounds, and then they allow the research to carry forward. So BOLAR provision is one which is helping in India also to develop the product which is already patented, and then you can also file the product for approval even though the patent is there. But you should not mass produce the product and then keep it in your manufacturing premises. So soon after its approval or its patent expiry has completed, you release into the market. So you should not do that. Only for R&D purpose, and then for approval process, okay, you can submit the application even though the product is patent protected. So that is called as BOLAR provision. BOLAR provision is relating to US, but in the same grounds in India also we have that provision. Okay. So relating to another aspect, what I have to emphasize is whether a foreign product, okay, going to another country via India, and then there is a patent in India, can be considered as an act of infringement. Okay. In most of the cases, especially in India, it is not considered as an act of infringement. So temporary halt in India is accepted because you are not selling it in India. Okay, so it is waiting, the vessel is waiting, or the airplane is waiting for some time, and later it is going to the destination country. So based upon the issues, India has made the provisions in India also. Okay, so these are some of the highlighting points which I have to emphasize. Okay, so with this, okay, I believe that you got the basic concept, and then most of the cases, if there are any questions, I'll take it, or else I'll wind up at this stage.
Sir, apart from the science students in the audience, we have even the commerce students.
Yes, yes.
So how these this session can be viewed for the commerce students, commerce aspect?
Yes, madam. That is the main reason I was emphasizing on the commerce
Yeah.
students also. They will be
Yeah.
helping in monitoring the things, especially. So even it's not just only the technical issues will be coming into picture. If they know the work process in an industry, they have to be coordinating with so many aspects. Okay, technology transfers, and then developing the technology, and then they have to communicate. Okay, and then so many personnel they have to meet, and then finally make the things in an orderly manner. Okay, in that way these people are also helping. Always the technical people will be working on the bench level, or developing the documents, or developing the key parameters and all. So filing things and all, it may be helpful by the other discipline people, making the things ready in the proper format and all, and then making it ready for the approval process and all. So it is not only the technical people, non-technical people are also helping the industry in several ways. So
Yes.
for example, data science. Okay, if you take into consideration what new products can be released into the market. Okay, so in that way you can take into consideration. For example, cosmetics are there. So whether any new product can be released into the market, any new design, or new problem is there in the market, can we come out with a new product? So in the same way, sometimes I meet the doctors, for leads. So they give this product is having a benefit. Okay, this combination is having benefit. So in that way, new leads will be coming. So in that way, we try to identify, and then finally, if possible, we'll start with the research, and then it may be fruitful in certain circumstances. So for example, if I go to a retail shop, okay, and then if I see the various commodities available there, and then if I do a data analysis, a particular product may be sold in large quantity, and then some products may not be moving at all. So all these strategies, okay, you have to be developing. Okay, all these prior research has to be done. So initially the company may be investing, and then there may be a benefit or maybe a loss in the initial days. So they'll come up with a strategy at a later stage, and then they'll put only those products which are necessary, and then obsolete products they'll be removing from the stores and all. So all these are required with a lot of technical and non-technical research, and then finally bringing the product into the market.
Yes. I think the commerce students and science students, they in the institutions, they can come together and do the research jointly.
Yes,
Yes,
madam.
yes.
In
Yeah.
dry laboratory research also, they will be more helpful.
Yes. So
Yes.
more sort of surveys and all they can do, and the survey part can be taken up by the non-science students. And once it comes to the lab aspect, the science students can take up, and collectively they can come out with some product.
This is one approach, madam.
Yes.
So in industries, multidisciplinary people will be working.
Yes.
So they will be placed in different places. Okay, and then finally they will be assigned with a sort of work. So this is one approach. What I'm saying. That is what.
Yes. Thank you, sir.
Yeah.
I think there are no questions in the chat box. That means your lecture was really like everything was crystal clear with so many examples you have quoted. So
Thank you, madam. So
yeah.
kind of you.
Now I invite Priyanka to present vote of thanks for this session.
Thank you, ma'am. Good afternoon, one and all. It's my privilege to propose vote of thanks for today's workshop. I would like to thank our speaker, Dr. Baya Subbarao sir, for enlightening us with the workshop. Sir has given insights on what is IPR, its roles and its classifications, and the brief history of IPR. Sir has started with the roles of individual components of IPR, where he described the components like patents, trademarks, designs, integrated circuits, trade security, geographical indications, protection of plant varieties, traditional knowledge, and etc. Sir has given insight.
Priyanka, we can't hear you, ma.
I think there is some technical issue, madam.
Yes, sir. She'll reconnect. I think she lost the connection. She'll reconnect
Yes.
again, sir. Meanwhile, students, anyone, can you share your views, ma, with sir? I think she joined, Priyanka.
Ma'am, am I audible, ma'am?
Yes, ma, you can carry on.
Yeah, ma'am. Sorry for that. It was small network issue, ma'am.
Okay, yeah, no problem.
Yeah, sir has given insights on the copyrights, like different types of copyrights. Sir has also, shared the IP offices, which was controlled by the government of India. And he has also explained about the patents and showed us the patent document. And sir has discussed a detailed description on the inventions which are not patentable, the types of patents, patent infringement and its types, and he has described the patent citations at US, the timescale of drug discovery patents and regulatory process. Sir has started explaining about the IT management necessity with lot of detailed description, and he has explained about the different approaches and the search engines, with also explaining what is an invention and what is an innovation, and also the approaches for innovations, data collection relating to pharmaceutical and product life cycle. Sir has concluded is by showing the Indian drug master files, market exclusivity expiry at US, Indian first generic approvals at US, orphan drug filings at US, and many more in the list. Thank you, sir, for being with us today and enlightening us with such an informative session.
Thank you, Priyanka.
Yeah, I would like to extend my thanks to our Honorable Secretary cum Correspondent, Professor Sudarshan Reddy, sir. And also I would like to extend my thanks to our Principal, Dr. Achita Devi, ma'am, for the support in conduction of the workshop. I would like to thank the institution's Innovation Council Committee for its support for the conduction of this event. I would like to thank our convener of the IPR cell, Dr. P. Jansi Lakshmi, ma'am, for the efforts that she made in conduction of this workshop. Lastly, I would like to thank all our participants, the faculty and students for joining the session and making it a grand successful. Thank you. Thank you, ma'am.
Thank you, Priyanka.
Okay.
Thank you, sir, for accepting our invitation, and we'll be collaborating with your college, sir, for the future programs.
Yes, ma'am.
We are looking forward for
Yes,
your further participation in future.
Yes, ma'am. Thank you, madam.
Thank you, sir.
Yes, I'm winding up, madam.
Yes, thank you.
Ma'am, I'm sharing the
Yes, ma'am. Please share the feedback form.
feedback form. We request the participants to fill the feedback form and give your opinion.
I thank all the faculty and the students for participating in this session. And now we are ending the session. Thank you for one and all.
We thank all the participants who have joined, and we request all to fill the feedback form which is given in the chat box. Participants can leave the session once the feedback form is filled.